the pleadings would be made available. What is Gatehouse's position with respect to that narrower form of empowerment?
Absolutely, and it's certainly true that there could be adequate alternatives to what we have now, which is wholesale empowerment. But I think before we even get to that question, there are a number of threshold issues that haven't been met. There haven't been particularized showing on the record with respect to all of those issues. And I think before we even get to redaction or any other alternatives, we need to address the fact that the First Amendment and the common law of Massachusetts has not been complied with in this case yet. And I don't think there's been any showing other than conclusory and speculatory arguments from the defense counsel.
Given your own filings and given the court's knowledge from the last many months, and your argument as to the intense public interest or intense media interest, isn't it fair to assume that if the identity of the juror were released before this court had any evidentiary hearing, the juror would be attempted at least to be interviewed by your clients and presumably many other media clients? And isn't that an assumption, a fair assumption to make? And this, I assume that Gatehouse would not believe that a lesser restricted alternative would be a form of prior restraint.
You're right, Your Honor, that it is an assumption. And I think there are multiple assumptions built into that assumption. And I think they're all conclusory, and I don't think there have been any facts on the record to support any of those assumptions.
Well, how could the defendant support the assumption that the media is likely to approach the juror? Certainly all the jurors were approached post-verdict to be interviewed. Given what you have indicated is an intense media interest in this very motion, how could the defense make a factual showing that your client is likely to proceed immediately to the juror's home as soon as the identity is released?
And so with all due respect, I believe that question should be addressed to the defendant. As Your Honor knows, the burden of proof in a case like this under the First Amendment is not on the media. The presumption is public access, and to the extent a party is seeking to impound judicial records, which is what is happening here, that burden at all times rests on the defendant, and it's a very strict standard. And so I think
why isn't it a reasonable inference the court can draw that the media will in fact disseminate?
It's certainly an inference that can be drawn, although I don't think there's any factual support, and I don't think there's anything on the record that would suggest that that's happened. I haven't seen anything suggesting that the media has tampered with a juror, has approached jurors to be interviewed. At least I'm not aware, and there's certainly nothing in the record suggesting that the media has done that in the past. There's nothing to suggest that it would. So while conclusory and speculative generalizations could be assumed, I don't think that complies with the First Amendment, in this instance. I think what you're assuming in that instance is essentially that the juror will ignore his obligation to tell the truth when he comes in. I think we're assuming if the concern is truthful testimony at an evidentiary hearing, we're assuming that a juror, first of all, would read the post-trial motion so that they would be interviewed by the court. We're assuming that the juror would then change whatever testimony he or she would be prepared to give based on what he or she has read. We're assuming that the juror would ignore his obligation in court to tell the truth, and we're assuming that Your Honor would not be able to adequately address the credibility. I think the other problem with the argument with respect to the truth fact-finding process is that it ignores the fact that every day of the week we've got witnesses who come in to testify, whether it's at a grand jury, whether it's at a deposition, whether it's at a trial, who are very well aware of all of the issues or many of the issues that they may be asked about. And we don't question those witnesses' ability to tell the truth. We trust them to tell the truth. That is standard practice in this court and certainly across the country. I think the other issue is that to me, and certainly the record doesn't reflect, how the publication of the full substance of the post-trial motions would have any effect that's different than what we know now. In other words, if
we know now from the filing that there's a claim that a juror was exposed to extraneous information, you don't know where, when, Who said it? How many people were present? Whether the juror said anything in response. You don't need the nitty-gritty facts on which the juror, if there's a hearing, would be examined or cross-examined.
Well, Your Honor, I think the cat is out of the bag if what we're concerned about is the juror testifying truthfully. The fact that this motion has been filed and the hearing is taking place today is publicly available. Everybody knows.
But isn't the art of cross-examination confronting someone with, you said X, but what about, weren't you at this location at this time?
That's exactly right. But to the extent that a juror is prepared to change his testimony based on the fact that he or she would be coming into the courtroom and ask questions about extraneous material that he or she was confronted with, I don't think there's any appreciable difference between what is available publicly now, the fact that these motions have been filed and we have a hearing today, vis-a-vis if that information was released. If the juror is going to change the testimony, I don't think anything is changed by the disclosure of that information. The only other argument that defendants raised, in the papers at least, is that the unsealing the motions now could potentially impact the media's, or the court's ability to conduct its evidentiary hearing because the media would be conducting an investigation. Just to address that briefly, I don't think that carries any weight. I think it's an attack on the media that doesn't go anywhere. Again, there's no facts, there's no case law in support of it. And in fact, I think it ignores the First Amendment's recognition of the role of the press and the media on behalf of the public, investigating the criminal judicial system. With respect to your point on the adequate alternative, which could be redaction, I think there are a whole host of other issues. As Your Honor, I'm sure, is well aware, the test is that there has to be an adequate alternative to a compelling interest, and that needs to be very narrowly tailored. It's got to be a substantial prejudice, and it's got to be very narrowly tailored. Here what we have is wholesale impoundment, the very opposite of narrow tailoring. Now, if we focus on what the compelling interest is, which I understand based on what defendants have said, and that's the truthful testimony of the juror at the evidentiary hearing. If that's what the compelling interest is, there's a whole host of alternatives and procedural steps and tools that we can put in place to safeguard that interest. And I'll just tick off a few of them. One, an admonishment from Your Honor, from the court, as the court does every day during jury trial, that the juror is not to look at media reports. That's certainly something that the jurors are very well familiar with, having sat here during trial for 10 weeks. That's number one. There can be admonishment. Number two, the juror is going to come in and sit down and take an oath to tell the truth. Number three, there'll be a reminder. There could be reminders from Your Honor throughout the testimony that they're obligated to tell the truth. Number four, we are going to have cross-examination. There will be careful inquiry. Number five, Your Honor will be able to assess the credibility of the witness to determine whether the witness is telling the truth. Number six, what we could have is a disclosure, full disclosure of certain motions and a partial disclosure of other motions. Number seven, as Your Honor mentioned, we could have redaction. And with respect to that, to the extent there is limited information that would be disclosed, only those portions where there's been a particularized showing should be disclosed. There has to be a particularized showing on the record. And Your Honor has raised the fact of the juror's identity. I think the Globe case, which Your Honor is familiar with, is dispositive on that point. Also, the Fujita case from January 2015, I think, is dispositive. The court has made clear that the media does have access to the identity of jurors post-trial. And so I do think that the juror's identity should be disclosed. The Globe case was also clear with respect to the particular juror, and I'm just reading from the 1990 Globe case. In these circumstances, protection of the reputation of some person who acted improperly.
I don't think there's been any argument here as a compelling interest reputation.
Fine. But I do think the identity of the juror under the case law, it is clear that should be disclosed. But in any event, unless the defendant can come forward with it.
Doesn't Globe and Fujita talk about, Globe in particular, when we're not dealing with the hearing itself, but there are several pages, I think, of Globe that is not addressed in either the Commonwealth's brief or, I think, Gatehouse's brief, where the court goes to the steps that lead up to an evidentiary hearing and suggests that many of the steps can all be closed. Closed hearings, closed depositions, closed interviews, because the evidentiary hearing hasn't yet taken place. So I don't see that Globe, the suggestion that Globe that you just made controls this issue. It doesn't Globe deal with access to a hearing when a non-juror was testifying, and what, if anything, could be redacted from the transcript of the hearings of the jurors.
That's right. The Globe case does deal with the judicial officer. It does deal with the jurors as well.
And it doesn't deal at all with anything, it makes no ruling at all, right, with respect to filings or proceedings prior to an evidentiary hearing.
Well, what it does talk about is the general principle that post-verdict matters that have been filed with the court or proceedings with the court, not matters that have been filed with the court, but post-trial proceedings are presumptively open to the public.
Right, and I don't think the defendant doesn't take issue with that.
Correct, but what the court focuses on, even with respect to the jurors, is only that information that was discussed during deliberations. So what was said during deliberations, the effect of what was said on deliberations, we understand that there is a special protection, a black box with respect to certain of those materials. So to the extent those materials need to be redacted from the post-trial motions, we understand that, we wouldn't dispute that. Well, we have a problem with this wholesale impoundment, including impoundment of legal arguments, identity of jurors, things that go outside of that particular jury deliberation exception. All of that, there's been no showing, no particularized finding, and that all needs to be disclosed. I would just add, Your Honor, that you mentioned earlier on that there is a strong community interest here. I don't think the community interest could be much stronger in any case than it is here. What we have at issue is a core right of the defendant to have a fair trial and to have a fair trial by an impartial jury based on evidence presented beforehand. And we've got a high-profile defendant, the former tight end for the Patriots, multiple weeks of trial, and so I think the community interest in this is incredibly strong. The other point is with respect to whether there should be a post-verdict inquiry, that itself is relevant in terms of the presumption of public access, because as Your Honor knows, whether there should be a post-judgment inquiry addresses that tension between the finality of judgments and our confidence in the juror system. So the community also has a significant interest in that. And I would submit that when you've got individual liberties and principles of that magnitude at stake, we've got to have careful showing on the record, which we simply don't have here.
Thank you very much. I will take the matter into advisement. I did want to raise, though, I had not ruled on any of the other motions because the Commonwealth had asked for time to respond. I don't know whether some of them there is going to be an objection, in which case the process could stop. The motion simply to authorize a subpoena to obtain the source of information provided to counsel. Is there any objection to a subpoena going out to get the name of the anonymous source?
At this time, I would say there would be, Your Honor. We've had some conversation with Attorney Sultan about other notes, etc., that may have been taken during the alleged contact. I'm sorry, the contact, not alleged contact. And we're now drafting a motion. I think we've hit a dead end with that. So
but even whether you get the notes or not, is there any objection to just getting the name of the source?
Well, I guess it just goes to the basis of the allegation. So I'd like to have all that information. I think that can be done fairly quickly. But again, before we can respond to that, his request is premised on information. I'd like to see all the information.
I've given you time to respond, and I will let you have that time, but I do think the earlier this action is taken, it makes the most sense. And to the extent the court allows the motion to ascertain the source, counsel might be able to provide a proposed next step, one of which would be a deposition, which the court, which under Globe would be sealed. and as Globe points out, there is no right of access to such a deposition in an inquiry, and the court then could make a determination based on the deposition of the anonymous source whether there's enough, with input obviously from counsel, to proceed to a formal evidentiary hearing at which the juror and or others might testify. But at least the issue of whether, I think when he came in, the Commonwealth requested 30 days to respond, and I allowed that time, but to the extent you don't need that full time, at least on the motion to authorize issuance, and you might both agree that whether to actually have a post-verdict hearing can be postponed until after there's some inquiry, and you might agree on the form of the inquiry.
Understood.
Your Honor, I just one related issue. I don't know if the court wants me to raise it now, if I may. As I understand it, the rules, the ethical rules respecting contact by parties with jurors change as of July 1. And I would ask that under the circumstances presented here, that the court enter an order precluding either party or its agents, in this case, from contacting the particular juror who is at issue in our filings. Again, in order to safeguard the integrity of the process. And I apologize for doing it orally, just occurred to me this morning.
Is there objection to that?
No objection.
The court will, maybe you could reduce that to a written order, but I do think it makes sense that there isn't a race by both of you to see who can get to the juror first, and that this proceeds in an orderly fashion. First hearing, if we are to hear from the source as to whether the juror should in fact be formally interviewed. Thank you. If you submit that, review it with counsel, and I'll just...
We'll try to agree on the form, Your Honor.
Thank you very much.
Would all rise? Court's going to stand in recess.
Three times in half an hour, the audio cut out on us.
Yeah.
What is going on? Yeah. One time I had to shut it off and turn it on again to get the thing to come through. That's scary.